This case, West Bay Plaza Condominium Association versus Sika Corporation, reported at 338 Southern 3rd, page 32, and decided in 2022 by the Florida 3rd District Court of Appeal, addresses whether a non-signatory party can be bound by a form selection clause, a provision in a contract or warranty that dictates where lawsuits must be filed, and under what circumstances such clauses may be unenforceable. This case is significant because it clarifies how courts treat form selection clauses when a party seeks to enforce a warranty without having signed it, and what limits exist to protect parties from unfair enforcement. Facts of the case. The West Bay Plaza Condominium Association, the plaintiff, filed suit against Sika Corporation, the defendant, claiming that defective sealant products were used in construction of its condominium. The plaintiff alleged a breach of warranty, seeking to hold the defendant accountable for the alleged defects. Sika warranty included a mandatory form selection clause requiring that any legal action related to the warranty be filed in New Jersey. The plaintiff, however, was a non-signatory to the warranty. The association argued that because it had not signed the warranty, it should not be compelled to follow this clause and file this lawsuit in Florida instead. The trial court dismissed the plaintiff's claims, enforcing the form selection clause, reasoning that the dispute must be litigated in the state designated by the warranty. The plaintiff appealed, arguing that requiring litigation in New Jersey would be unfair and would prevent its claims from being heard locally. Two main issues arise in this case. One, under Florida law, does a form selection clause in a warranty bind a plaintiff who is a non-signatory when the plaintiff's claims are directly based on that warranty? And two, under Florida law, can a plaintiff avoid enforcement of a form selection clause if doing so would be unjust or would effectively prevent the plaintiff from having its claims be meaningfully heard? Rules of law. Form selection clauses are generally enforceable, even against non-signatories, when the plaintiff's claims are derived directly from the contract or warranty containing the clause. Also, enforcement may only be avoided if the plaintiff can demonstrate that enforcing the clause would be unjust, unreasonable, or would deny meaningful access to the courts. Application of the law. The appellate court reasoned that the plaintiff's claims arose directly from Sika's warranty. Although the plaintiff was a non-signatory, it sought to rely on the warranty to assert its claims, while attempting to avoid the form selection clause. The court explained that allowing selective enforcement by taking only the benefits of a contract while rejecting its burdens would undermine the purpose of a form selection clause, which is to promote predictability, fairness, and prevent form shopping. The plaintiff further argued that litigating in New Jersey would impose significant burdens and was therefore unjust. The court rejected this argument, holding that mere inconveniences does not rise to the level of injustice. To avoid enforcement, the plaintiff must show that the form selection clause would effectively block access to the courts or prevent meaningful pursuit of claims. In this case, the plaintiff did not meet this standard, as New Jersey courts were fully capable of adjudicating the dispute. By emphasizing these points, the courts reinforced the form selection clauses are strong contractual tools, and parties who rely on a contract or warranty must also respect its provisions, even if they were not the original signatories. Conclusion. The appellate court confirmed the trial court's dismissal. The verdict was in favor of the defendant, Sika Corporation, because the plaintiff's claims were based directly on the warranty. It was bound by the form selection clause, despite being a non-signatory. This case underscores the enforceability and significance of form selection clauses in Florida contract law. It confirms that parties who seek to benefit from a contract or warranty cannot selectively ignore its provisions. Even non-signatories are held to these clauses when their claims rely directly on the agreement. The only circumstance in which enforcement may be avoided is when doing so would be fundamentally unjust, such as effectively denying access to courts. The case also serves as a reminder for business and property owners that form selection clauses are powerful contractual tools, and understanding them is critical to planning legal strategies and avoiding disputes over venues.